This case starts like many DUI hearings, but quickly takes a sharp turn no one in the courtroom seems fully prepared for. A driver, allegedly intoxicated, found unconscious behind the wheel, vehicle in drive, foot on the brake. On paper, it sounds like a textbook case for probable cause. But here's where things get interesting. The entire case hinges on one critical detail: location. Was he actually driving on a public road, or is there just not enough clarity to prove it? Because in court, assumptions don't hold up, evidence does. And today, we're about to see how one missing piece of detail can completely shift the outcome. Stay with us, because this judge is about to make a call that might surprise you.
To a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street.
Right here is where the prosecution begins laying out the foundation for probable cause, and at first glance, it seems strong. The officer describes classic indicators of intoxication: bloodshot eyes, confusion, unsteady balance, and even a witness account placing the defendant unconscious behind the wheel. Add to that the field sobriety test results and a breath test reading well above the legal limit, and most viewers would assume this case is already locked in. But here's the legal twist. None of that matters if the state cannot clearly establish that the defendant was operating the vehicle in a public place. DUI laws require that key element. So the real question becomes, did they actually prove where this happened clearly enough, or are they relying on assumptions?
Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 5 out of 8 clues observed on the walk-in turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.179 and 0.175.
Where was he? Was he in the middle of the road?
It sounds like, yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
Don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says 400 block of West Gray Street is a public street.
I mean, I need more information. I mean, does it say he's on a street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But in regards to the location aspect of it, there's nothing further stated on that.
Yeah, I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really, be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm going to find no probable cause.
And here it is, the moment the entire case starts to unravel. The judge isn't focused on intoxication anymore. That part is practically uncontested. Instead, the spotlight shifts to a much more technical but crucial issue: location. The court needs clear, explicit evidence that this happened on a public roadway. Not implied, not assumed, proven. And as the back and forth continues, you can feel the hesitation, because the report just isn't specific enough. This is a perfect example of how even strong evidence can fall apart if one legal requirement isn't properly established. So, what do you think? Should the judge move forward based on common sense or stick strictly to what's documented? As this wraps up, the judge ultimately decides there's no probable cause to proceed, reinforcing a powerful legal principle: details matter. Oh, and assumptions don't win cases, facts do. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw dropping courtroom breakdowns.